Alrighty.
Hello everyone, my name is Mary.
And I'm Andrew.
And today we're going to be talking to you about Florida Statute 798.02. Now before I start, I just want to ask you guys, how many of you have ever been in a serious and committed relationship where you've ended up living with your significant other? Or how many of you are currently in a serious and committed relationship and are planning to? Well, before you do, just some food for thought. According to Florida law, Florida Statute 798.02 states that if any man and woman not being married to each other fluidly and lasciviously associate and cohabit together, or if any man or woman, married or unmarried, engages in open and gross lewdness and lascivious behavior, they shall be guilty of a misdemeanor of the second degree, punishable by either a $500 fine or 60 days in jail. Now, according to a previous case in Florida, Bowles v. State, lewd and lascivious are terms which are synonymous with wicked, lustful, unchaste, licentious, or sensual design on the part of the perpetrator. Now, there are two parts to the law as a whole. The first part states that if you are living with, say, a significant other and you're having sex, it's illegal. The second part says that if you're engaging in open acts of sex, like say you touch someone inappropriately in public, that's illegal. What we're arguing today is about the cohabitation part. That it should be in your privacy rights to like do whatever you want in the privacy of your own home. So, according to Florida, the image on the left is wrong, and the image on the right is right. And this is the second part, which says that you're not allowed to be doing that in public, right?
I can't see that.
That's a nun and a priest, and you know they're having anal or something.
Oh, okay.
Anyways, so what's the problem? The problem is that this law is archaic. It was implemented back in the 1800s, and it is clearly not enforced. How many of you know people that are living together but they're not married? Exactly, not enforced. So according to Marianne Franks, which is a legal professor, she says that having a law that is not enforced encourages disregard for the law. Now, on the flip side, there's another problem against people that think that the value of marriage throughout the years has diminished over time. And they believe that cohabitation ruins that whole idea of marriage. So why do we have this type of morality law? Well, the reason is the second part of the law, which states that you're not supposed to be acting in any lewd or lascivious behavior in public. Like I said before, touching someone inappropriately in public. Like a prostitute comes up to you and they touch your thing or whatever. That should be something that you should have rights to sue or something like that because you're being violated as a person. So who are the people that cohabitate? According to studies, college students and recent graduates are among the highest amount of people in Florida that cohabitate together. Why? Because most of us are in school, getting a lot of loans, and we're in debt. And we're either working minimum wage jobs or we're not working at all. So many of us decide to live with our significant other and try to like split the cost. And let me remind you that the cost of living in Florida is very expensive, especially in Miami, which ranges from rent as low as $800 a month to as high as $4,000 or even more. Another group that cohabitates with each other are older unmarried couples, and the reason that they do that is for the economic benefits that they could get.
So here is a map. I don't know if you can see some of these areas clearly. The Department of Health and Human Services says that since the 60s, the number of unmarried cohabitators has increased from about 400,000 to over 6 million. As you can tell, being in a high population state, we attribute to that number greatly. The highest amounts of increase in cohabitating unmarried couples are within Hispanic and low-income demographics. So it's further proof that people do it for economic reasons. constitutionality of this law is in question. It might not even be constitutional, but because no cases arise for it to be challenged, because it's never prosecuted, it still exists on the books. Back in 1964, McLaughlin versus Florida, it was a case against an interracial couple that this chapter used to have a section 5 that stated that no interracial couple could cohabitate, and there was no requirement for lewd or lascivious behavior. You just couldn't cohabitate. And that was a different burden of evidence than the second section, which we showed you. And they struck it down because it was biased towards one group. It's potentially biased towards heterosexual couples because in 2003 in Lawrence versus Texas, the Supreme Court struck down sodomy laws, which sets kind of a standard for what you do in the privacy of your own place. It's your business and it's not the state's business. It also might step on freedom to associate, which is the basis for a lot of constitutions worldwide. Today it's so common that even this Keith London, he was going to run for mayor in Hollandale. He's been living with his girlfriend for 8 years, and recently, politically, someone threatened to file a complaint because he was living with his girlfriend, but the police, they don't even hear it, like they don't file a complaint because no prosecutor will enforce it. It does say that people, well, this local news channel says that people are arrested for it, but since none of the cases get prosecuted, it shows that there's some abuse of this law. Other legal things that occur because of this law is that if you're living with a significant other who's providing for you and is legally qualifying as a dependent, you can't claim a deduction for them for the IRS, from the IRS, because legally your living situation it's illegal in Florida, so you can't be a dependent of one another. In the case of Michael and Terry Shivo, Michael was denied visitation rights because he was living with a girlfriend in Florida. The courts looked at that and used it as a basis for their visitation rights ruling. These are all unintended consequences of the law. The law isn't actually enforced.
So, there's this guy, he's a Republican called Rich Bergman, and he decided to appeal this law back in 2011, House Bill 4021. But this bill was quickly disregarded by Florida legislature, and the repeal provisions relating to living in open adultery just deleted the language that prohibited couples lewdly and lasciviously associating with each other. The bill was born in August 23rd, 2011, and it died quickly in March 9th, 2012. This is the amendment, I guess, that he made to the law. And the crossed out part is the law itself, and then the red is something that he added. So basically, he just took out the language of like people should be able to cohabitate with each other, but people that commit lewd and lascivious behavior openly should still be responsible and charged with the misdemeanor of either the $500 fine or the 60 days of jail. So in order to come up with a solution, I decided to take it to a social media. So I went on my Facebook and I posed a question what people thought about this Florida Statute 798.02. And I had a very different variety of responses. Some people blame the government, some people blame religion, some people just thought it was that it was against our privacy rights. And then there was this one person who happens to be my cousin. She is an extreme conservative, and she thought that this law should be implemented because it was voted upon by the people of Florida, and we still want it, which is why it's still in the books. But to be honest, I don't think that this law is, a lot of people aren't aware of this. And if people become more aware of this law, then able to appeal it will be much better. And so we did a little makeshift petition